as per usual. Jack Bierman. Michael Cole. Adam Kress.
Here.
Thanks, Adam. Renee Landers. She may be 30 minutes late. Robert Lesnick.
Here.
Thanks, Judge Lesnick. Jeff Lubbers.
Here.
Roxanne Rothschild.
Here.
Canning Strother.
Here.
Lou Varelli.
Here.
Melissa Wasserman. Russell Wheeler.
Here.
And Matt Weiner.
I'm here. Thank you.
Are there any committee members present whose names I did not call?
Matt, am I a committee member?
Chris, yes, you are.
Okay, good. I'm here then.
Great.
Okay. And I think I am not a committee member, but I'm an invitee. Is that right?
Yes, you are. But you are a member of ACUS, so you have full speaking privileges, though you do not have a vote on this deliberation.
Thanks.
Next, the second roll will be the names of ACUS members who are not on the committee and their alternates. Again, say here if you're here, as well as our consultants. Jeremy Grayboys.
I'm here.
Jen Celine.
Here.
Laura Barheit. Laura, you did not come through there.
Here.
Oh, thanks, Laura. Laura is alternate for Dan Cohen. Sarah,
Nope.
Oh, I'm sorry. No, you are alternate for, remind me.
Nope. I'm a member.
Oh, you're a member. I'm sorry. I was messing you up with the next person, Sarah Neural.
Here, and I'm the Dan Cohen alternate.
Yep.
Thanks.
Thank you. Sorry about that. And Nina, you already checked in. All right. Are there any ACUS members present whose names I did not call? Okay. Please reach out via the chat function or via email if you experience any technical difficulties during the meeting. The ACUS staff will be happy to assist you with troubleshooting or moving to alternate means of participating. I'm going to hand this over to Matt to explain the ground rules and get us started.
Thank you, Matt. Welcome, everyone. I'm going to just go through the standard ground rules for discussion, which you're probably all familiar with, or most of you are familiar with, but I'll go through them nonetheless quickly. Please note that only ACUS members, including government members and their designated alternates, public members, senior fellows, liaison representatives, and special counsel, whether or not on the committee, and their designated alternates have full speaking privileges. To avoid background noise, I'd ask that you keep your microphones on mute and either use Zoom's hand raise feature or add a comment in the chat feature if you'd like to speak. I'll then call on you and you can unmute yourself. Please then remute yourself when you are done speaking. I'd also ask that ACUS members and their designated alternates, if at all possible, use the webcam. With respect to attendees other than ACUS members and their alternates, participation requires the unanimous consent of the committee members. Time permitting, I'll consider calling on such attendees at appropriate points, and we'll presume that committee members consent absent their raising an objection. If any such participant would like to speak, please so indicate in the chat feature or by using Zoom's hand raise feature, and wait to speak until I call on you. You can then unmute yourself and then please remute yourself when you're done speaking. For all participants, please use the chat function only to indicate that you'd like to speak, or for committee members and their alternates to vote when asked to vote through the chat function. Please do not hold any sidebar discussions or put substantive comments in the chat feature. Finally, only only members of the adjudication committee, including government members and their designated alternates, public members, senior fellows, liaison representatives, and special counsels have a vote. Please do not vote unless you're a committee member. Matt Booth and I have a list of committee members in case, like Chris Walker, you're unsure of your committee status. So Matt, is there anything more before we proceed to the discussion of the recommendation? I'll just point out this is our last committee meeting, and I fully anticipate, given that the progress that Nadine and the committee made at last meeting, that we will have no trouble getting through the recommendation in the time allotted.
No, I think we can just pick up where we left off.
Okay, so this is how I'm gonna proceed. Especially for those of you who were not at the last meeting, my understanding and recollection is that the committee got through and reached agreement on the content of recommendations or paragraphs 1 through 16 of the recommendation. And Matt, here, correct me if I'm wrong, that since the last meeting, ACA's staff has made some implementing changes to paragraphs 1 through 16 to reflect the agreement reached by the committee at the last meeting. Is that right?
Correct, and we circulated that revised draft to the committee last week.
And that's right, and that's what we will be working off today. So I did say that. So what we'll do is we will go through the remainder of the numbered paragraphs. Then we will turn to the preamble, which reflects certain changes requested by the committee at the last meeting. Am I right on that, Matt?
Correct. There was broad discussion of the preamble, though not a line-by-line edit.
So as Nadine does, what we'll do is I will go through and invite comments on each paragraph of the preamble. And then what we will do finally is we will go hopefully quickly through each of the numbered paragraphs of the recommendation to ensure that there are no additional changes and the committee members are satisfied with the content of those paragraphs. So I indicated that we would start with paragraph 16, with paragraph 17. Let's actually start with paragraph 16 because Adam Kress had a thoughtful comment on paragraph 16. And so what I'll do in the first instance is just turn it over to Adam to explain his comment and then invite any discussion that committee members may wish to have on his amendment or comment.
Thanks, Matt. Yeah, and apologies for not raising this the last meeting. I was having some computer issues towards the end of the meeting, so I wasn't able to speak up at the time. Yeah, I just was thinking that perhaps this paragraph could benefit from a bit of maybe expansion, a bit of clarification, just as to what we mean by I guess just had some questions about what was meant by the need for notice and comment rulemaking. Was it the suggestion that there be situations where the PAS decision maker or there's a review taken of PAS decisions that have been made and determination was there was maybe a thinking that or regret that the decision couldn't come out a different way because the agency was bound by its regulations, in which case I guess that would suggest there'd be a need for notice and comment rulemaking. But it seems like there could be situations where it may not just be that the decision maker was bound by the regulations, but that maybe procedurally the agency or the decision makers should just benefit from notice and comment rulemaking. I've seen that happen at my agency before. So that explains why I proposed these changes, and also a bit of a clarification as to who exactly would be the ones benefiting from notice and comment rulemaking or the guidance.
Thank you, Annie. Before asking any of the ACUS members if they wish to comment on Adam's comment or amendment, let me just ask Matt or Jeremy or Jen whether they have they want to say anything in response to Adam by way of explaining what the intention was here or otherwise.
Sure, I can jump in. I mean, I think you identified one situation, Adam. There might be other situations in which there just seems to be a lack of consistency among lower level decision makers, a lack of clarity as to how a policy should be interpreted or applied, all those sorts of situations where case by case adjudication may be one way to improve policy, the quality of policy making, or improve consistency. But of course, generalized rulemaking provides another option and may have benefits in certain circumstances.
Um,
One.
Jen, I'm sorry, Jen.
Sorry.
I'm sorry.
I was just going to follow up and say, one, I actually like the softer language of may benefit from as opposed to a need for, because I think it's a little bit more encompassing and allows a little bit more flexibility for the things that we've just identified. So.
Okay. Let me turn, unless there's anything else from Matt, Jeremy, or Jen, let me recognize Nina Mendelson. And before I do that, Matt, could you just, if I miss someone's hand or anyone's trying to seek recognition through the chat function, could you just let me know?
Absolutely.
Okay, thank you. Nina?
Thanks. Can you hear me okay?
I can.
Okay, super. Thank you for including me in this discussion, and I really regret that I couldn't be at the last meeting. I really like Adam's amendment. I might suggest that the words, the agency, comma, lower level adjudicators, or the public, comma, may benefit from. That would be a sort of a friendly amendment. But this amendment goes to a broader issue that on rereading the recommendation, I realized it doesn't address, which is there is a broader question of whether agencies should be developing policy through rulemaking, adjudication, enforcement priorities, or some combination of those. This recommendation really doesn't address that at all in a, it is really just assumes that decision's already been made for the most part, with the exception of paragraph 16, and just goes to what the process should be for adjudication. I think the amendment's a good one. I also was going to propose a sentence for the preamble that makes clear that we're bracketing this broader issue of policymaking choice, but I can pause that till later. I just wanted to flag the issue for now and why I think it's good that this amendment be included.
Okay, so Nina, if it's okay with you, why don't we? So you're contemplating a change to the preamble rather than a change to one of the numbered paragraphs. Is that right? So if it's okay with you, why don't we just reserve that issue until we get to the preamble, and there will be ample time to address your point, which I think is a good one. Let me turn to Roxanne, though. You have a comment on 16, Roxanne?
Yeah, I was just going to say that I agreed with Adam's proposed edit, and I also like Nina's friendly amendment as well.
Okay, and Adam, do you like Nina's friendly amendment?
Yes, yeah, all good. Thank you.
Okay, is there any objection to Adam's amendment as amended? So that amendment is agreed upon, and so now let's move to recommendation number 17. Now, Russell has a comment on that, and Adam has a comment on that, though Adam's comment may be more apropos of paragraph 21. In any event, let me turn to Russell to discuss his comment. Russell?
Thank you, Matt. It was nothing more than my view that the list of delegable functions, some of them seemed rather substantive to me, like recommending case dispositions and a variety of other things. And I just wondered if that generic list was a little too all-inclusive of whether or not there are some tasks on there which are not basically ministerial, which is the impression I get. I may be reading it wrong, so I don't feel strongly about it, but if other people see it that way, perhaps we can adjust the language somehow or other.
Why don't we just turn to the consultants in the first instance just to see if there's any explanation they wish to provide for the inclusion of the items in paragraph 17 here, in whatever order you want, or whomever wants to speak.
Sure, I can start. Yeah, I think some of these are more than ministerial, and I think that's the intention. I mean, obviously, when agencies delegate final decision-making authority, that's a delegation of authority that's far more than just merely ministerial. I will say for this list, all of these are drawn from real-world examples. I think there's probably some policy choices for the committee to make, but all of these examples do exist in the real world. at least at certain agencies. And you do see wide variation of what kinds of tasks are delegated.
Yeah.
I guess the real question is whether or not they're all routine, because that's the intro to the list.
Jeremy, did you want to speak to the qualifier routine?
Yeah, I mean, I think these are tasks that are considered routine functions that are delegated. That is, they are, for example, when you receive a petition for review that is clearly untimely, it may not require intervention by a PAS official. A clerk, for example, can act to dismiss, and that's not uncommon to see. I don't think all of these are routine in all programs and all agencies, but certainly all of these are considered routine in at least some programs.
Jack Bierman, and I think Jack I'm sorry, I don't know if Jack was Jack is with us now. I don't know if he was with us when the roll was called, but
I wasn't. Sorry, I came on a
no,
little
you
bit
don't need
late.
to apologize. We're thrilled to have you.
Thanks, Matt. I'm looking at this. I agree that there are circumstances where it would be appropriate to delegate these functions. These are functions that are often delegated even in courts of law. They delegate to clerks to decide which cases ought to be brought to special attention of judges, like in many different circumstances, but I don't think they're routine. And I'm not sure. So it may be that the 17 ought to be rewritten just to say when a PAS official serves as adjudicators, agencies should delegate functions, including when appropriate, and then go from there. I mean, I don't think they need to be routine in order to be delegated. Especially some of them, like for example, identifying unappealed decisions that may warrant review by the PAS officials. I mean, I think in a sense, it's routine in that you would do it all the time, but it's not. But if you're taking routine as something that's not important enough to bother the PAS official, actually, that is really in support of the PAS official's adjudicatory function. So some of these are just things that the PAS official doesn't need to be involved in, but others of these are things that help the PAS official maintain the sort of control from the PAS official that I assume is the whole goal of having PAS official involvement. So I'm not sure they're all routine.
And you'll note also, Jack, in 17F, the word routine does appear in connection with motion. So
yeah.
Anything more before we? No, go ahead. I'm sorry. Before we
turn
to
so I'm saying, so maybe what we want to do is use the word routine as is in B and in F when we think it's a routine matter, and then in other situations just omit the word routine. And so therefore, by admitting the word routine, we are at least signaling that we don't think it's routine. That's not why we're advocating delegation. We're advocating delegation maybe because of the burden on the PAS officials and the lack of necessity of their involvement.
Let me come back to you in a second to see where, if anywhere else, the word routine should be included. But let's just turn back to Russell first.
Well, couldn't you just strike the word routine in paragraph 17? Delegate functions that do not require?
Yeah, I guess I would be happy either way. I just don't want to make it seem like if in an agency where the PAS officials actually do the function, that they're not somehow doing something that they don't aren't really required to do. I don't know. I'm close to indifferent on that.
All right, so you're indifferent to routine, whether to include the phrase that do not require personal attention by the PAS officials. Anyone else? Does anyone else wish to be heard on this? On these, the Russell's, in effect, Russell's comment on number 17. Is there object? Jack, are there other? I'm sorry, Jeff, please.
You're on mute.
I thought of doing exactly what Russell suggested, but then I looked at the one that says C, identifying unappealed decisions that may warrant review by the PAS officials. That's not exactly something that doesn't require the personal attention of the PAS officials. I mean, I think this is what Jack was saying earlier, that, this is, we're trying to help the PAS official identify unappealed decisions that may warrant review by him or her. So that's not that doesn't fit into our line that do not require personal attention. Right, Jack? I mean, so I think we can't do exactly what Russell just suggested, because that doesn't fit with C and maybe a few others. So I guess I come down to where it stands now with crossing out all the blue on number 17.
Does it work if all of the blue text is stricken? Agencies, when a paid official serves an adjudicator, agency should delegate functions, including the following. Do we need to describe generally what functions that we have in mind here before enumerating examples?
No.
I think that works. I think the only other remaining question then is, in several of these, we exclude routine examples of them, and others we don't use that. So that kind of implies that in all the other ones, they're all routine. So I think we need to just go over these a little more carefully and make sure that, that they're all considered routine enough to delegate.
All right. So before we do that, is there any? Is anybody on the committee have any objection to using the language that appears on the screen right now? That is, with the blue text stricken. And there's no functions doesn't need to be qualified with a word like certain functions or anything like that. Just leave it the way it is. Jeremy, are you happy with that?
I don't think that do not require personal attention by the PAS officials may be the best words, but at least the idea was that you should think carefully about which tasks you're delegating. There's lots of tasks that can and should be delegated, but there might be certain tasks that you should perhaps not delegate. That would be my only concern.
Jeff, did you have something further, or you? Roxanne?
What if we just switch the language very slightly? So it said, when a PAS official serves as an adjudicator, agencies should delegate functions when appropriate, including. Because that would hopefully get to Jeremy's thought that it needs to be when appropriate.
Jack? Thank you, Roxanne. Jack?
Yeah, I'm looking at this list. Part of the problem we're having, I think, is that some of these are so routine that you would never even imagine a PAS official doing them. I mean, managing the proceedings during submission of materials, managing docket and case files. Those things seem to be like what a clerk does. And I wouldn't even think those would be delegated. They would just not even be part of the adjudicatory function in a sense. So I don't know where this is going, but and then on other things, like when it says conducting the initial evaluation of petitions for review and petitions for reconsideration, what does that mean as far as initial evaluation? Does that mean make a recommendation to the PAS official, or does that mean actually making decisions on them and then putting the person in a posture of appealing? So as I'm looking at this list, I'm starting to feel a little bit uncomfortable with how it all fits together as one single recommendation.
Well,
I think it almost goes without saying that D&E or something that would be delegated to some other people, or it wouldn't even just would be part of the function of a different office.
With the result that some of these should just be omitted from the list, Jack, like what you would call like clerical or ministerial functions.
Yeah, I mean, I don't know I think the people that wrote this, maybe can weigh in on what I'm saying. And again, on A, I'm not sure. Yeah, my inclination is that, that goes without saying. But when you talk about responding to routine motions or initial evaluation of petitions for review, and even dismissing things. I mean, we're talking about making a final decision that's reviewable or not reviewable by the PAS adjudicator. I'm not clear where we're headed with that.
Jeff, we're talking about assigning the function, not really delegating the function. So the word delegate, I think, is a little misleading for things like D&E.
Jeremy, you're one of the quote people in Jack's words who drafted this. So why don't we? I think so. Why don't we hear from you on this, if okay? That's okay.
I mean, I don't think delegate is the wrong word, because frankly, all these statutes basically say this official shall do everything. In many cases, you see, like, the board should basically do everything with cases. So, I mean, I don't think describing as delegating is inherently wrong, but I have no problem with saying assigning functions. Frankly, most of what happens in an agency is through some sort of delegation, whether it's what we call a formal delegation or just things that are assigned to staff. As to the need, maybe there's no need to say some of these things, I wouldn't assume that. I think we see wide variability. I think when you're talking about, say, independent boards and commissions, where you have a sort of well-understood and well-developed century-long understanding of what PAS officials do, you certainly see this. But I think when you're seeing more sort of ad hoc adjudication in the executive departments, I think you see more variability, and you might actually see PAS officials doing things that you might not expect them to do.
Adam?
Yeah, I agree with Jeremy. These all did strike me as tasks or responsibilities that are delegated, I guess. And it's getting to my comment, like where I kind of got hung up is that there seem to be two very different kinds of delegation that's captured by this list. And one is, at least is how it struck me, one is delegations of authority, like the power to dismiss a petition that's filed out of time or to approve a settlement agreement, where there's like a formality there. And then the other bucket of delegations is, and maybe someone else kind of had said this, is kind of like assignment of work, that the research is being delegated to a clerk, because of course the PAS isn't going to be wouldn't probably be worth their time to be doing case law research, or even like the initial review of filing. Someone in the office is putting eyes on everything that's being filed and can kind of escalate issues to the PAS. I'm not sure. I'm not saying this would be appropriate, but maybe we consider breaking this list out into those two into buckets that are like that, and then maybe that would help with some of the other concerns that have been raised, where trying to kind of create two different categories of the more what I view as the more meaningful delegations of authority. Then also, and I agree with Jeremy too, I think it could be helpful to kind of just describe the types of tasks that could and should be delegated to others. And it seems like that's kind of consistent with the point made in 21 that regulate, I would think that when describing in your regulations, and I think 21 uses delegations of authority, like it seemed to be that 21 was trying to get at letting the public, or letting people that practice for the practitioners for the agency know, what aspects of the PAS's authority are going to be delegated to others. And a question that I had to that point was, when we are talking about, dismissing a case, I'm assuming that the dismissal order would be under the signature of the person to which it's been delegated, but maybe that's not true. I think sometimes I believe the judge that I worked for would, tell his assistants, if the parties, if there's an unopposed motion to extend time, you can just stamp my name on an order that grants it. I don't know if that's something that others really needed to. It's a form of a delegation. I don't know if I would call that a delegation of authority, but I'll stop there. So that's
we'll definitely
thank you. Comment.
And we'll definitely come back. Your point definitely has to be addressed in connection with paragraph 21. I think it's M. Jeremy had his hand up, Janet had her hand up, and Jeff had his hand up. So why don't we go in that order, Jeremy?
Yeah, I would just say, I think there's sort of 4 different types of tasks we're talking about here. Some are just routine case management, receiving files, docketing cases, scheduling things. Some are sort of triage functions where it's like, I'm looking for certain characteristics to highlight them for PAS officials. Then you have sort of initial review functions where for every case, my job is to go through a voluminous record and organize it, summarize it to help the PAS official reach their decision. And then finally, in some cases, you have essentially final decision-making authority delegated to a lower level official. I might be missing some buckets, but I think that's, if you want to divide these up, I would say triage, initial review, final decision-making, and case management.
And you would do that in the context of paragraph 17, and then there might be a parenthetical with an EG or something. Is that sort of what you have in mind?
It could be. I mean, it's up to the committee, I think, whether you want to have this sort of grab bag approach of just listing different kinds of functions that should be delegated. But if you want to separate them out into distinct buckets, I think that's one way you could do it.
Jan?
I was just going to follow up on some of the things that Adam and Jeremy said in terms of if we're thinking about particularly agencies that may either not necessarily have a very formalized process and are sort of doing things ad hoc, or which we saw a lot in case studies, particularly where it isn't like a traditional independent board or commission. In addition, we've seen agencies really struggle with this sort of thing as they are revising their adjudicative systems, either in response to changes in case law or other things over the past 10 to 15 years. And so I think one thing that this particular paragraph would be nice to do is to prime agencies to think about, these are the things that you need to think about that they may seem very straightforward, but agencies really do struggle on a daily basis of like thinking through exactly what happens when and who participates in each of those processes. So I don't think it's a bad thing to lay everything out, given what we've seen in our case studies.
Thanks, Jen. Jeff and then Jack.
So a middle ground might be just to say, to use both words, assign and delegate, assign or delegate, sign and or delegate functions. And then I don't think we necessarily need to break out the 2, 3, or 4 buckets with little headings, but I think we could put them in order from sort of most ministerial to least ministerial and just sort of do it that way. And just keep a list from A through K, but try to put some order into the list.
Jack?
Yeah, apropos of what Jeff just said, I was sort of trying, do we have them all up there now? Is K the last one? So no. I was, there's more than that. There's L. I can't see them all now.
L and M.
What is it? L and M? Preparing, transmitting decisions on parties, making them public available.
Especially M. M is not ministerial at all.
Okay. So what I did with the ones I could see at the time, I would leave maybe L and M. Well, M seems to be the adjudicator ought to make that decision. But I had sort of lumped it together. Like I would take D and E. But listen, hear me out before you start typing, okay? Because you may not want to do it, and it's a lot of editing the way I'm looking at this. I would take D and E and make them a new A and just say routine case management, case management tasks such as, and then I would put everything that's in D and E in one, like managing dockets and case filings, managing dockets and proceedings and case filing and proceedings, all that stuff in one. Then I would put F as the second one. What
about I?
I haven't gotten there yet.
I know. Wouldn't that be second?
What is I is recommending case dispositions?
No. Conducting legal and policy research.
Yeah, I suppose. I mean, let me get through this before we start editing because it's a lot, and now you've changed all the lettering, and so I can't tell what's what anymore. But then I had the old F, which was I can't tell now. The old F was responding to routine motions, and then in B, dismissing, denying, and granting, for these routine reasons. And then I had for H and A, I had, instead of initial evaluation, I had preliminary evaluation and leave it the same. A, and then H also conducting the preliminary review of lower level decisions, evidence, and arguments. To make it clear that preliminary was teeing up the PAS official to make the decision. And then I would have go to old C, G, I, J, K, L, M, like that. That seemed to me to be a way it would group them into sort of different categories, and also changing the initial to preliminary, I think makes it clear that it's in support of the ultimate decision making by the PAS official, because I think that's the intent, right? Otherwise, I don't know what initial evaluation means. Does that mean they could decide it?
Jeremy, what's on that small point, initial versus preliminary?
I think preliminary is fine. What you described is what we meant.
All right, so let's change it. Let's go with preliminary for that. I doubt there's going to be any disagreement on that one. And then Jeff, Jack, are you done, by the way?
Yeah, I am. I had the order, so I would start with routine case management tasks as A. Then for B, I would have what was in old F, which is responding to routine motions, I think. And then for C, I would have old B, original B, which is dismissing, denying when it's untimely and stuff like that. I mean, we could quibble with the order. And then the next one I would have would be original H, which was conducting the initial review, but changing the word initial to preliminary. And then A is the next one. Oh, original A is the next one, but with changing the word preliminary to preliminary. And then what was originally C?
Identifying unappealed.
Yeah, unappealed decisions.
Right. Yeah, right there.
Yeah, I would put that one as C.
So it's F now.
Yeah, I would make it as F. Yeah, right. Put it as F. And then old G, encouraging settlement, approving settlement agreements. Now, do you mean, Jeremy, do you mean that they would have final approval over settlement agreements?
In some cases.
Okay.
It depends on the program.
And I'm not sure, do you want to say both then, approving or making recommendation, and reviewing and approving settlement agreements? I don't know. I mean, do you want to mention that they might not have authority to? I guess it's including, so it's fine. Encouraging settlement and approving, and then I was the regular. The rest of it is fine, I think, in the order it's in. Although, do you really mean for them to have the power to make issue stays?
Again, some agents, I think the FAA, that's been delegated, for example. So that is drawn from a real world example.
Okay.
And you still have everything's qualified by when appropriate still, is that right?
Correct.
So that ought to take care of Jack's problem. And with respect to the reordering here that Jack suggests, reordering and revision, does anybody want to comment on that, or is everyone on the committee satisfied with that, with what Jack's done?
I'd like to I think it's just kind of what I had in mind, and I approve of most of it. I would just move up conducting legal and policy research higher up, because that's something that sort of stands to reason would be done by non-PAS people.
And you like that, Jack, right?
That's fine.
All right, anything else on this paragraph 17? All right, no objection. So it looks like we have an agreement on paragraph 17. And of course, everything, is subject to a final check and potential revision by the committee on style. And we'll say a word about that before we adjourn for today. So with that, thank you. Let's turn to paragraph 18. Any comments or proposed changes on paragraph 18? I do have just myself one maybe clarifying suggestion, which is to make clear that each delegated function is referring to those that are enumerated in paragraph 17. But are there any comments or changes to paragraph 18? All right, if there are none, let's turn to paragraph 19, and I think we should start with Russell, who has a Renee, did you have a comment?
I did actually, and I apologize for being late. I know what the rest of the discussion has been, but I was just a little struck by that word lower level adjudicators and staff. And I know it's not intended. I mean, I think it's meant to be, an org chart kind of reference, but I'm just wondering if there's a different way to convey. I don't have a suggestion, but a different way to convey that without,
sounding like lowly.
Yeah.
Matt, was there a discussion on that terminology the last meeting or the one before, and how is it, if I can just turn to you, how is it used elsewhere in the recommendation, or is it used elsewhere in the recommendation?
It does appear elsewhere in the recommendation, and I do not recall a conversation or discussion of that term at the previous meeting.
I was not able to come to the previous meeting, so I'm sorry that I wasn't able to make the comment sooner.
Jeremy, I don't know, can you draw any generalizations about whether that's a sort of, ACUS commonly distinguishes among levels of officials. Is that a common way to describe agency officials as lower level officials or lower level adjudicators?
I mean, yeah, you see a mix. Some early recommendation on delegations of authority uses lower level officials. I'm sure I could identify a few others. I just looked at agency appellate systems. It says hearing level, but I don't think that works given the wide variation you see in adjudicative systems.
Subordinate?
Is that nicer than lower level? I don't know.
I don't know.
Sounds more clinical. Sounds more clinical to my ear, but yeah.
Renee, do you want to propose a change here?
I don't have a word, which is why I was a little late on the trigger, but for raising my hand, but I'll think about it.
All right, why don't you think about it? We can certainly come back to it. Roxanne, do you have a thought on this point or something else with respect to paragraph 18?
I agree with Jeremy that lower level might be used frequently, but here we're basically making a distinction between PAS officials and other people, and those other people would be career people. So I suppose we could say career adjudicators and staff. Not sure how strongly I feel about that, but I'm just throwing it out there as an option.
Or maybe non-PAS adjudicators and staff.
Jan? And then Jeremy.
Yeah, I was going to say non-PAS because we do see sometimes a PAS official will delegate authority to, say, just a presidentially appointed official who then, does some things or decides to delegate to a careerist. So I think making that distinction would be make me a little uncomfortable to say career.
Yeah, I think ACUS normally avoids the word career because it can be imprecise. Jeremy, do you have any thoughts on this?
Not a good solution. I mean, I think the idea of lower level, whether or not that's the right word, is important because really what we're talking about here is, an adjudicator at an earlier stage of adjudication essentially certifies or refers a case that they're reviewing. Basically, I think this is really important. I think it warrants higher review by an appellate reviewer. So it's not just sort of people reviewing. It's like the adjudicator who was involved in the case at a lower level, or in some cases, a sort of intermediate appellate body as a whole. I don't know how to get to that point, but I think the staging, the sort of levels, is actually an important consideration.
Does anybody want to propose a change to a substitute for lower level, or should we retain it as written?
What
Well,
about
I mean,
lower level stage adjudicators? Would that help?
I mean, we
I'm sorry,
could talk
Jeff, can
about
you say that again?
Lower level stage. I mean, if Renee's worried about sort of this is kind of a derogatory way of referring to them, and we're talking about the stage, not the adjudicator.
We would just because lower level is used repeatedly throughout this, we'd have to think about whether we mean that distinction, the lower level stage, for every reference.
Right. Maybe
You want to come back? You want to come back to this one?
I mean, would you want to just say adjudicators and staff at a lower level of adjudication? So it's not modifying the adjudicators and staff, but referring with just an earlier stage of adjudication?
at an earlier, did you say?
Earlier level, I think, is fine too.
Earlier stage or earlier level?
I only use level because that's what we used in timeliness. We referred to multi-level adjudication. So for consistency between recent recommendations, I would say level, but I think even with that one, we debated level versus stage.
Jack?
What about something like non-PAS agency adjudicators?
Somebody responded to that already, I think. Was that you, Jeremy?
Right. The idea is it's not non-PAS officials who might work with the PAS officials. The idea is it's adjudicators who have reviewed the case at an earlier level, say an ALJ, who says, there's something big in this case. I think I need to certify it to a higher level authority to review.
So what about other agency adjudicators?
I don't know if that captures the idea of stages. I'm using the word stages as opposed to levels.
It seems it's maybe not quite, it's not sufficiently specific, maybe.
I mean, can I just chime in on that? The problem is this number 18, it's not, none of these are directed at any particular delegation. If you want to say something specific about the delegation of other lower, preliminary or earlier adjudicatory functions, then it would make sense. But you're talking about, for example, delegation of routine motions, which may have nothing. So, in other words, 18 captures everything that's in 17. It's not like 18A is only about making a preliminary decision or initial decision. So
where you see 18A more often is, for example, if you seek review by the Secretary of Labor of a decision of the Administrative Review Board, you file a petition for review with the Administrative Review Board, and the Administrative Review Board decides whether to refer that petition to the Secretary or not. That is a direct delegation from the Secretary. So there are a number of instances in which very specific tasks are delegated, typically around petitions for review, to adjudicators at earlier level of adjudication.
I understand that. My point, Jeremy, is that the text of number 18 is too general to capture, to make 18A make sense in the way you're saying it. Do you understand what I mean? In other words, 18A delegations under 18 could be to any of the tasks in number 17.
That's the idea.
What you mean to say is that there are certain, if you want to make recommendations about specific tasks going to specific other agency adjudicators, then I think you would want to say more, not less. I guess that's what I'm coming from.
I don't think you can. I mean, the idea here is that for each thing that you delegate, figure out who is the appropriate delegate. And there's really wide variability. I mean, I would feel uncomfortable making any generalizations, frankly. In some cases, I don't think it's appropriate at all to delegate, say, to lower level adjudicators.
Right.
In other cases, there's good reasons to.
I understand
vary
that
across programs.
No, I understand that. But my point is that but 18 without the background knowledge that you're bringing to it, 18A is unintelligible.
But look at the opening sentence in 18, Jack. It says the agency should determine which is best suited to perform each of those. So they have to. They're not saying that everything in 17 can be performed by everything in A through E. They're supposed to make a determination.
Okay, but I'm not seeing anything in 18 that's being directive in terms of when is it that people in A are the most appropriate? When is it that people in B are the most appropriate? And without that, I'm finding it. I just think it's really, really vague.
I mean, the idea is to which delegate is the best suited to perform that function in a manner that is fair, the most accurate, that it promotes consistency, that's the most efficient and promotes timeliness. And you see really wide variability depending on what the task is, what the program is, what resources are available, whether or not there are concerns about separation of functions. All those things come into play in terms of sort of fairness, efficiency, timeliness, et cetera. And I don't think you can generalize more than that except to say, here are the values you have to consider in deciding which task should go to which delegate.
Right. My inclination would be to delete everything between from options include to the end of E, and just leave the first and the last thing. I mean, I just don't think unless you want to tell people like, so which task are you talking about when adjudicators ought to be? I don't think you're not giving them advice about what factors are leading you to which of those 4 things in your list.
I think that's
the point.
Purposeful. I think that's purposeful because those things do vary, not just within agencies, but also within programs. And it's going to be up to those who work in those programs or with those programs to make those determinations.
Yeah, I don't see what's wrong with having a list like this. We're not trying to be directive here. We're just trying to list some options.
Right. The idea is there's different options for structuring staff support. And it's just identifying different options for structuring staff support. But I think that's the best you could do.
But I think that maybe I'm just not seeing something. But maybe what I think is that the list is the people that are eligible that you're saying ought to be considered for getting being delegated functions listed in 17. So maybe the list comes first, and then it says when determining which of these people to give it to, consider these factors. I mean, otherwise I'm just not seeing the purpose of the list.
It's the point. It's a pointer, really.
Okay, I'll just withdraw because no one else seems to. Maybe I'm just missing something here.
What about with respect to 18A? Is everyone on the committee satisfied with the revision to 18A?
Why don't you say who serve at an earlier level of adjudication?
Is that okay, Jeremy?
Yes.
You need a comment after fair, by the way, 2 lines up.
So maybe I can understand this. Tell me what tasks are you talking about? Would you consider being delegated to adjudicators and staff who serve at an earlier level of adjudication? Because I assume they've already served at an earlier level of adjudication in the case. So what are they going to continue doing now that's different from what they already did?
At some agencies, typically where you have an intermediate appellate board, they review petitions for review. They might certify cases in which they think that sort of own motion review by a PAS official is warranted. Those are the sort of typical tasks that you see assigned to lower level officials, but again, not universally.
Does it help at all if you put options may include? Does that do anything for you, Jack? No?
Interlocutory appeals, I guess, is the other big bucket where you see intervention by lower level adjudicators. But there's a number of tasks like that, usually around triaging what should a PAS official consider or not.
Let me ask you this: we got to get past this point here. Does anybody agree with Jack in terms of the listing here?
Well, Can I just say one thing about that? I mean, I see what Jack is doing, because if you're not really getting all this background in the conversation, it's hard to see in some ways what the difference is between 17 and 18. And so, and I didn't think of this until Jack raised this question. So maybe the lead, phrase or sentence in 18 should be something like, in determining which office or officials should be best suited to perform, are best suited to perform these functions when a PAS official serves as adjudicator. These are the considerations. I'm not, speaking, that's not a real good sentence yet, but I think that, to really signal that this is about the person and not the task. Although it is about the task too.
Well, maybe we just need to tie 18 and 17 together a little more clearly. Because if you just read 18, you don't know what we're talking about.
Matt, didn't you suggest that at the beginning of this conversation, like the first comment that you made, I thought was to include a reference to 17?
Yeah, that was just making clear that the delegated functions are referring to 17. I don't know if that gets at what we're discussing here. I don't know.
I think that helps Renee's point. Perform each assigned or delegated function mentioned in paragraph 17. But put in assigned also, because now we changed that in 17.
Where do we stand here with, is everybody, I mean, subject to Jack's concern, is everybody otherwise in agreement with the way paragraph 18 is now written?
What if it said possibilities instead of options?
Roxanne?
It was my understanding that 17 was giving examples and not necessarily a complete and exhaustive list of the types of things that could be delegated. So I think I think that if we say in paragraph 17, we should say something like such as those in, or something like that, which is basically, I see what you're saying, which is 17 says, here are the things you can delegate. And 18 says, and here's who you're going to delegate them to. I understand the breakup, but I'm just, I wouldn't want to sound like 17 is setting out a definitive list of here are all the things and the only things that you can delegate. And then 18 says, and here's who you can delegate them to.
Does the word each then, is that does each have to go then?
Yes. Take out each.
It's after perform. Best suited to perform.
All right, do we have agreement on 18? Anyone further? Anyone else? Anything?
I have one just not substantive comment.
Well, if it's, yeah, okay. Is it stylistic? Let's just get this done real quick.
It's about the fact that we switched adjudicators and staff who serve at an earlier level of adjudication. If we can just make a note for the Committee on Style to go through the rest of the document and make sure that we are consistent across the entire document with that language.
That's a good comment, and that's certainly something the Committee on Style should do. Anything else on 18? I think we have agreement on 18 now. So why don't we go to 19 and turn to Russell?
I'm reluctant to bring up what I regard as small points because it starts a half-an-hour discussion. But my only point there was that you need perhaps a parenthetical phrase to indicate that these considerations are not unique to decisions made by PAS officials, along the lines of the language I stuck in the commentary there, in the sidebar.
Anyone else on this one? Jeff?
Mine's different from Russell's, but I just mine is the word sensitive on the fourth line of this paragraph. Sensitive seems potentially too broad. We're saying the agency should redact information that is sensitive. Well, one person sensitive could be, you know, doesn't like the way.
What are you proposing? Confidential or something else?
How about just protected from disclosure?
Roxanne?
I think, Jeff, that the reason they might use the word sensitive is that there's this term of art that we use for sensitive personally identifiable information, SPII. It's something we always have to be on the lookout for to make sure we're not posting on our public websites. And so that's maybe why the word sensitive found its way in there. I just wanted to let you know that, because there's basically personally identifiable information, PII, or SPII, which is what you really want to keep off the website.
Okay, well, let's put that term of art in there then. I mean, because, you know, I don't think we want to be telling agencies they should redact anything that they consider to be sensitive from their opinions. So, but if it's a term of art that agencies understand, then.
Jeremy?
I mean, I have no dog in this fight, but sensitive is a term we've used in several recent recommendations. I mean, this was drawn basically verbatim from agency settlement agreements, which says that when an agency posts settlement agreements, it should redact any information that is sensitive or otherwise protected from disclosure. I believe that was a result of debates over things that may not be protected, but agencies may not want to proactively disclose in the context of other documents.
The settlement agreements are a little bit different from, you know, precedential decisions. But I might have objected to it in a previous one too, but this one seems like we're opening too big of a loophole here. So what was that phrase? Sensitive
or otherwise protected.
No, I'm talking about what Roxanne said. Sensitive
Personally identifiable information. And it may be a different thing than what Jeremy and others were trying to get at when they used the word sensitive. But for us, SPII is defined. We know what it is. It's a person's name plus, and then a list of types of information that you should not be posting, like their bank account number or social security number, et cetera, et cetera. So at least SPII has a definition.
We already say redact identifying details to the extent required to prevent unwarranted invasion of personal privacy. So that should cover all that. I mean,
I'm not saying we should have sensitive personally identifiable information in there. I'm just was wondering if that's where that word sensitive came from. I agree with you. It is a bit vague on its own.
I appreciate your clarifying. It's just that we're already saying they should redact personal, you know, privacy information. If we just said information that is protected from disclosure and redact identifying details to, wouldn't it cover everything that's in that phrase you used? I just don't like sensitive on its own.
Jeremy?
Can I make one recommendation so we don't get bogged down too much in language and just say we cross-reference earlier recommendations on public availability of adjudication materials and agency websites and public availability of precedential decisions? Because I think Russell's right. It's the same considerations. All that's unique here is that if it's a PAS official, you need to think strongly about putting it on your website, and you should clearly identify which decisions are made by PAS officials. Otherwise,
so what would be the change here?
I think you would just take out the in publishing decisions, agencies should
That whole
should follow the best practice identified in, I'm blanking the numbers, but adjudication materials and agency websites and precedential decision-making and agency adjudication.
That's okay with me.
Renee?
I just want to say that sensitive does have this, like, it is like a term of art in, you know, privacy and national security and all that kind of thing. So I think by taking it out, I mean, I understand where Jeff is coming from, but I think by taking it out, we might be narrowing or being too restrictive about the kinds of things that should be considered for redaction from these postings. Because, you know, I don't think we have anything in this otherwise that says anything about, you know, the agency's interest in not disclosing certain information relative to the agency and things like that. So I think sensitive actually does that work.
Well, what do the previous recommendations say? I mean, if they cover it, we don't need to try to say it in a slightly different way here.
Doesn't Jeremy's change address your concern, Renee? It's gone, right?
Right. And I'm saying that maybe it shouldn't be gone. That's what I'm saying. Wait a minute. But if we deal with it and these other things.
Yeah, that's the question. How do we deal with it in that recommendation? Can you post that, Jeremy?
Sure. Yeah, I mean, I guess the critical thing would be, is there anything distinct about redaction in decisions by PAS officials versus decisions by other? But I don't think there is.
But we can't spend the time now reading each line of those recommendations. That's not going to work here. So where do we stand here? Jeff, what's your preference? I'll just turn to you.
I mean, I'm happy with incorporating by reference the previous recommendations, assuming that they, you know, they cover all the points that we want to cover, and, you know, but I think it's hard to know without looking at them.
Russell, does this edit take care of your concern?
I'm sorry, I couldn't maneuver yeah, it's fine with me.
Jeff, what would it be okay if we were to move on and you could take a look at the other recommendations, and certainly other committees members can as well, and see if there are any changes that need to be made?
That's fine.
Okay, so why don't we turn to 20? Are there any comments or changes to paragraph 20? 21, if I can turn to 21 now, and just bear with me for 1 second here. Adam certainly has a comment on 21, and in particular 21M. Adam?
Thanks, Matt. Yeah, I guess I'm not quite so bullish or interested in the idea that I had raised. I think through the discussion of paragraph, I think it was 17 or 18, and I think it was Jeremy that was saying that there's a lot of kind of variability in the tasks that agencies assign, and perhaps it's best to just kind of leave some flexibility in 21M as to what items that were identified in 17 that are significant delegations of authority, just to kind of keep that open. But yeah, my comment initially was, you know, would it be beneficial to kind of give some examples of that? And also the reason I had put that comment up in 17 is because it was guiding how I kind of viewed the different items listed in that paragraph. I think it's obviously, you know, people have different ways of looking at the items in 17. As far as maybe some are more ministerial than others, but I was viewing it as kind of which ones are delegations of authority and which ones are kind of delegations of something else, and that was kind of guided by this item, which is why I raised it earlier. But as far as my suggestion that maybe we should have some examples, I'm okay, you know, letting that go given the variability.
Okay. Thank you. I saw, Jack, you had a comment that popped up about commas and semicolons. Why don't we put that in the hands on the committee in style, and just because there may be an AICA style convention on this point in any event. Is that okay? Anything else on paragraph 21? Thank you, Adam. So you're satisfied now on 21M that it's the phrasing is adequate, and the agencies will need to figure out, each agency will need to figure out what's significant for it and so forth.
Yeah, all good.
Okay. All right. Why don't we turn to 22 then, which is the last numbered recommendation. And Jeff, you chime in after we get to 22, or throughout just chime in whenever you want with respect to the incorporation by reference of the other recommendations. But why don't we just turn to 22 and to see if there are any proposed changes to paragraph 22. Anyone? All right. Why don't we now turn to the preamble? Does that sound okay, Matt? And Matt, should we go? Well, should we turn? So there was. Are there additional comments that have been inserted here from Nina that came from Nina? Just tell me what we have on the screen. What we have here.
These are all comments that were resolved at the previous meeting. Nina sent some comments when she was having technical difficulties a little while ago. I've asked Kaja to insert them into the document. I'm not sure exactly where they are because, well, there's the first one there.
Is Nina on the line now or no?
Hi, I can you hear me?
Yes, I can.
Okay, I can explain quickly if you want me to. I had terrible technical difficulties, but fingers crossed, they're resolved.
And I know you also, we do want to get to, and why don't you raise this whenever you want, since you had raised it earlier. You had made a point about the choice between rulemaking and adjudication for policy making and so forth. So in whatever order you'd like to take them.
Okay, that's at line 34 of maybe it might be 35 now of the preamble. And I did send the proposed language to Kasia and Matt and Jeremy. So it's really just to clarify that this recommendation does not tackle the broader questions about policymaking choice.
Okay. Thoughts from committee members and others on Nina's proposal on lines 34 through 36. Nina, you wouldn't put guidance in here, would you?
The what?
You wouldn't put guidance in here.
You could. I mean, guidance is a form of rulemaking. It's exempt rulemaking. We could say or other means. I feel like if we just have a super exhaustive list, I'm not sure what the point is, just as long as everyone's on notice of what this recommendation isn't tackling. But I don't have a strong feeling either way.
Any thoughts on Nina's suggested inclusion? Nina's suggested change here, addition? I mean, as a committee member, I would support it. And if there's no objection to its inclusion, let's include it. What else do we have from Nina? You have you have another change here on page 1? Could you just want to explain the change?
Yeah, this is to the description of Arthrex, and I actually consulted offline with my colleague Chris by email, not on chat. But
well, if you and Chris can reach agreement on Arthrex, I think the rest of the committee can go along with it. But I'll let you.
That's kind of what I thought. And it seems he also flagged the language. The report language seems to me on the description of Arthrex in the report seems completely fine. But this preamble language is confusing and I think might yield some not incorrect implications. So the sentence would specifically call out the fact the court found an appointments clause violation rather than just referring generally to the Constitution, and then just clarify that that they found a violation because final decision authority was vested in non-PAS adjudicators, and those adjudicators were not subject to at-will removal. Both of those factors were mentioned in the Arthrex analysis. The remedy is correctly stated, although I would hope that the Committee on Style would take a crack at that second sentence. It just seems long and hopefully could be tightened up. But I didn't want to propose a substantive change to it now. But the first sentence I think needs a substantive change because otherwise it implies that the only appropriate remedy is to require all adjudication to be vested in PAS officials. And I don't think the court has yet gone that far.
Before we get to that, Matt, would you just bracket that second sentence for the Committee on Style Review, and then we'll move on from that. That's certainly unobjectionable. Nina, do you have something else? I'm sorry.
I had a third comment.
But with respect to this point, you were done on this point on the
this is it. Yeah, this is right. This characterization of Arthrex, and Chris can speak for himself, but I also did circulate this to him.
Is Chris on in the meeting still or no?
Yeah, he's here.
Chris?
Yeah, no, I think I think it just more accurately captures the holding of Arthrex. I agree with the language.
All right, so I agree with it as well. Are there any committee members who object to the modification that Nina suggested or Chris suggested? So, yeah, Jack?
Yeah, I'm very skeptical that at-will removal, non-at-will removal had anything to do with it. But I don't think it's misleading. They mention it, but the point to me was only that they had final decision making on reviewable authority, because certainly the director of the PTO could take away any case in the middle of while they were deciding it, which is the equivalent of at-will removal in this connection.
Well, I think I actually before this meeting, I actually rechecked the language in Arthrex, and I think this is a more accurate description of what they actually said. I think we could try to read the tea leaves to try to predict what they think is more important, but I think at this stage we should just be going with what they said.
Yeah, I agree. I agree, Jack, that's probably where the court's going eventually, but I agree with Nina that that's where the court is right now in Arthrex.
I think also this change is really good because the other description in the preamble was kind of vague. You had, the why is really important.
Jack, you're okay with this as a summary of the holding, even though you question what might happen in the next case, for instance?
I don't think it's an accurate summary of the holding, but I'm not going to hold things up on that. So just go ahead.
All right. Does anybody object to the revision that Chris Walker has proposed? I'm only identifying Chris because he's a committee member here. All right. So let's move on. Let's move on to you have another comment. Is that right, Nina?
Yeah, I have one other comment, and that is there are two references in the document, one in the preamble and one in sorry, I have to find the line number. One in paragraph 1 to the idea that PAS officials should decide questions that are politically sensitive. And it appears on line 114 in the recommendation. I'm sorry, and also line 127, my mistake. 114, 127 in paragraph 1, and then lines 57 and 58. They're probably 58 and 59 now in the preamble.
All right, so it's in the preamble as well?
Yes, correct.
All right, so let's see if we can't reach agreement on it in the preamble and then make some kind of conforming change if everybody agrees to the recommendation. Okay. So what do you propose in particular?
Well, right. So I think My concern is I'm not sure what politically sensitive is aimed at. It's not defined. It's not defined in the report, and it's not defined in the recommendation. And as I read the report, it seemed to be that there was an issue flagged specifically by Russell Wheeler, which is, I think, a fair point, which is that it's possible that PAS officials might have, more clout or more wherewithal to take on perhaps misdeeds of another political official. And so perhaps politically sensitive could capture that. But politically sensitive could also capture some other things, including, perhaps something which is an important policy decision where we particularly want democratic accountability, but that's already captured in other words in both the report and the recommendation. And my concern is that politically sensitive could also capture some things where we have greater concerns. So, for example, I would say the Plan B decision in both the Obama and Bush administrations was an example of a politically sensitive decision where PAS supervision maybe didn't necessarily contribute to, transparency or expertise. Or we could have cronyism problems where, again, PAS official review might not contribute to what we might consider a high quality or a high integrity decision, which is all by way of saying, because politically sensitive is such a, I don't know, a term with so many meanings, I would just like to see it actually deleted, and we just stick with the recommendation that PAS officials look at exceptionally significant, broadly consequential issues or important issues of policy or discretion, and just leave it at that. I just didn't understand what it was adding, and it seemed to me to open up too many questions that it doesn't answer.
So I have a suggestion on this.
Please, Jeff.
And you won't be surprised that I agree that sensitive is too vague there, but nevertheless. So what if you just said better equipped to address political considerations that may arise in the course of adjudicating individual cases?
I guess one question is, how does that add anything to policy considerations? To me, political could be anything that, the White House thinks is important, and I'm not sure we are weighing in on all of that.
Well, why would they? I'm not sure short tenure would help them deal with policy issues.
I think we're saying that. So one of the problems with just looking at the preamble is, I think, in the context of the recommendation language, you can see that politically sensitive doesn't actually add much to what's already there. This sentence being all by itself makes it look like we'd actually be dropping a lot if we dropped it. But I think it doesn't add much more clearly in these other areas in in paragraph 1.
Any additional thoughts here? Jeremy, do you have any thoughts here?
I'd be fine with getting rid of it personally. Nina, you captured it correctly. It's taken from Russell Weaver's report. The one program he identifies is sort of removal of political appointees, and that it might seem unseemly or be difficult for career officials to remove political appointees. I don't know if there are other programs quite like that. So that's all it's taken from. But I'd have no problem with deleting it.
So as a committee member, I'll propose the deletion of the sentence in question. Does anybody have any disagreement with its deletion? And then could we just move down to the corresponding part of the recommendations to see what, if any, changes need to be made there?
So I'll just say in line 114, I guess it's 118.
Right.
We would just take politically sensitive out of the list and make it exceptionally significant or broadly consequential. And then in line, it's probably around 130 now. It's little 2A. Cases that involve legal or factual issues that are exceptionally significant, broadly consequential, or broadly consequential. And then, of course, we have important questions of law, policy, or discretion in the next little sub paragraph.
So the amendment to 2A would just bring it into alignment with the proposed amendment on 117 through 18.
Correct.
Okay. Here too, I'll propose this as a committee member that that we make this modification. Are there any objections to that modification? All right, Nina, does that bring, have we gotten through have we addressed all of your comments?
Yes, and very efficiently. Thank you.
Well, thank you. So why don't we go through the preamble paragraph by paragraph, and I'm just tracking Nadine's practice here, and see if there are any revisions that any ACUS members or committee members would like to propose. Let's start with the first paragraph. Anything on the first paragraph? Second paragraph, starting on line 10. I suspect that we have nothing on the third paragraph because we've already addressed the characterization of the holding in Arthrex. So that brings us to the next paragraph, which is now on line 32. This recommendation does not address. We've also made a change to this paragraph as well, which I think would suggest that there's nothing else that we need to do on this paragraph. Anyone on this paragraph? Let's go to the next one that appears on line 39. Instead, this recommendation provides a framework, so forth. Any proposed changes to this paragraph? Let's turn to the paragraph starting on line 45, beginning with to develop effective. Anything on this paragraph?
Matt, down 3 lines is there, where it says there, is that should be the?
Yeah, I believe so. Jeremy? It's just a typo, right?
Typo.
Yeah.
Thank you, Russell. Next paragraph, beginning on line 51, first, as the administrative conference has previously noted. Anything on that paragraph? Let's turn to the next paragraph on lines 56, beginning with second. I suspect that we won't have any comments on this paragraph, but let me just confirm that. Anything on that paragraph? All right, next paragraph, beginning on line 63, beginning with third. Any proposed changes to that paragraph?
I have one.
Thank you. Thanks, Jeff. Let's hear yours.
Maybe two. So on the second line, PAS officials are often nominated by the president because of their political affiliation. I think we should say at least in part, because otherwise it looks like they're only, their president's ignoring their other qualifications. So
that would seem to be unobjectionable, but let me just ask. I don't think we have any objections. So we've that change is agreed upon. Jeff, what's your second one on this paragraph?
So the couple sentences after that, unlike officials appointed by the president alone, however, PS officials are also confirmed by the Senate. Of course, there are some officials that are appointed by the head of a department. I don't know if we need to.
It's PAS.
Mention.
Jeremy, you want to just speak to why it's drafted the way it's drafted? I don't think it's suggesting that there aren't officials appointed by department heads, but should we make a change here?
Yeah, this is just intended to distinguish PAS officials from other types of officials, but of course you're right, Jeff.
I don't know, unlike inferior officers, or unlike officials appointed by the president or agency head, president alone or agency head, however.
You want to say department head? Is that more?
Department head? Well, that's a term of art, but
yeah.
We've explained what it is in the footnote.
Yeah, you're right. You're right. Jeff, are you finished? But should I turn to Jack for a moment here?
One other point. I think we say on this page, on the other hand, 3 different times. I think we can use some other phrase like conversely or in contrast or however or something like that. Just Committee on Style can look at the number of times we say on the other hand. And
Okay, Matt, you'll just mark that for the Committee on Style.
And I assume the footnotes will have id where you've repeated the exact same footnote in like 10 and 11.
Yes.
Okay.
Yeah, I think that's true of the report too. Jeff, I'm sorry, are you done?
Yes.
Jack.
Well, first of all, just on this one little sentence, I would say appointed by a department head or the president alone, because otherwise it's not clear that alone applies to the president. But also, I just want to register something that I brought up in the first meeting, which I think most people seem to disagree with me about also. I don't know why I'm so disagreeable on this, but I really question whether PAS status is what cures the Arthrex problem. And I just want to, because I think if someone's clearly an inferior officer and they can make a final decision on behalf of the agency, it's the same. It's the appointment problem seems to me to be the same. And I just want to register that because I think that's a serious open question. So I'm not sure PAS status cures as much of the constitutional problem as we think it does, because it's really between inferior and principal, not between PAS and non-PAS. I don't expect any response to that, but.
All right. Yeah, I mean, I suppose, Jack, you can, if you want to put a comment on the docket for the record, you could certainly do that. Or you could raise it in a comment at the plenary session.
I think maybe I'll just put a comment on the docket because I just do think that PAS doesn't mean principal. It just means inferior or principal. It means an officer that hasn't, and if they're inferior, that Congress hasn't specified any other appointment method.
Okay. All right, so Jack, no, I think you've been well understood on this. I actually don't remember exactly what the discussion on this point was at the first committee meeting, but I'll assume you're okay if we move on here. Okay, thanks, Jack. I think it would be a good comment for the record for anyone at the plenary session who wants to take a look at it. So why don't we move on to the next paragraph on line 76, which begins with fourth. Are there any proposed changes to that paragraph? Let's turn to the next paragraph on line 83, beginning with fifth. I think this is the last paragraph. Jack? Oh, I'm sorry. Who's speaking?
Jeff. Just to shorten this a little bit. So in the middle, where on line 89, after on the other hand, I don't think we need to restate the fact that PAS officials who often have many statutory responsibilities and may oversee large programs. We've already said that.
So if there's no objection, let's strike that phrase. Is there any objection? All right, you won that one, Jeff.
Okay. And I'd like to put the word also before raise in the second to last line.
I don't think there'll be any objection to that either. Any objection to Jeff's proposal to add also on line 93 where indicated? All right, so there's no objection. So now we'll move on to the next paragraph. Unless, Jeff, you had anything else on that paragraph.
No.
Let's turn now to I think it's the last paragraph here on beginning on line 95, which among other things identifies prior ACUS recommendations of particular note. Jeff, nothing here? You must have something on this one. No?
No.
All right. Anyone else have any proposed changes to lines of the last paragraph of the preamble? If not, we'll turn to the recommendation. Jeff, and I haven't forgotten your point. I forget what the issue we discussed with earlier that you were going to review the recommendations on, but we will get to that.
We'll get to that.
Okay, so we'll get to that. I just forget what numbered paragraph it is, but I won't forget about that. So we've been through all of the paragraphs. The content has been at least preliminarily or tentatively approved or conditionally approved, whatever word you want to use. Let's just go through. Each of the paragraphs. I hope quickly and see if there are any additional changes before we proceed to a vote on the recommendation. Let's start with paragraph 1. Anything on paragraph 1? 2?
Yes, I have something, and I apologize for missing the last meeting. But the parenthetical in this one that says, e.g., a judicial officer, capitalized. I know we're probably referring to the Department of Agriculture's official who is called the judicial officer, but we don't identify it as such. And it sounds like it's an officer in the judicial branch when you read it. So maybe we could say something like, e.g., an adjudicative official, just e.g., some other adjudicative official or something like that. But calling it a judicial officer there and also in 3B is confusing unless you know about the agriculture department.
Does any other department use that or agency use that term other than ag?
The Postal Service, historically the EPA.
We talked about this last time.
I missed the meeting last time.
And I raised the same point. That judicial officer
sounds like an officer in the judicial branch.
A longer word for judge. But when it's explained to me that there actually are positions who are judicial officers and they capitalized, at least for what it's worth, that was fine with me. I would just note that in 3 you need to capitalize it also at 3B.
Oh, so why don't we say, can I suggest an adjudicative official such as the quote judicial officer unquote in the U.S. in the Department of Agriculture?
But there are other agencies. I just heard.
E.g.
Jack, you're smiling.
I love having the same argument twice, and I think I have a simpler. See, originally my innovation last time, if you remember, was to say capitalized judicial officer, because before it was judicial officer uncapitalized, and no one knew what the heck that was. How about saying an agency judicial officer each time we have it capitalized? Would that solve your problem, Jeff? Just call it an agency judicial officer?
Yeah.
That's pretty good, Jack. That was very constructive.
Maybe the footnote could drop.
Thank you. I'll take that as a negative on the other comments I've made today.
No.
Maybe the preamble could mention these judicial officers somewhere. But anyway, yeah, that helps.
So it'll just be an agency judicial officer. It won't be a proper noun, and so it'll be lowercase j and o. Is that right?
Yeah.
Okay.
And also in 3B.
Yeah, and that's what Russell pointed out. All right, so we need to make a conforming change to 3B.
I'll shut up after this. Once you say agency judicial officer without the capitalization or quotations or anything else, then it just sounds like an agency judge.
Put quotes around it.
I would leave it capitalized.
All right.
And I would put quotes around it anyway. That's what they're called.
All right, everybody's happy or happy enough now to move on.
Right.
Paragraph 3, other than the particular change we just addressed. Anything on 3?
Line 1, the second to last line in B. Let's see. Where is it now? No, infrequently, where it says infrequently. I would say only occasionally. And individual cases only occasionally raise novel or important questions of law.
I don't think there'll be any objection to that, is there? All right, anything else on 3, Jeff?
No.
All right, anyone else on 3? Otherwise, let's move to 4. Paragraph 4.
Wait a second. I'm sorry, 3C. Who hold the other office by virtue of holding that office. I didn't get that. this option may be appropriate, for example, when individuals who hold the other office by virtue of holding that office. What does that mean?
So this was intended to implement a discussion last time. It's not when the Attorney General delegates decision-making authority to the administrator of the DEA, for example, it's not because that individual person has greater expertise, but by being embedded within DEA has greater expertise to subject matter expertise. So it's the idea that the position comes with certain institutional benefits, not that the individual has certain expertise.
Well, could you shorten it by saying when individuals, by virtue of holding another office, have just to shorten it?
Yes.
Yeah, that's great, Renee. I think everybody likes that.
Yeah, that's
I
right.
I feel valued, Matt. Thank you.
That's why I'm here.
And then in D, the italicized language talks about delegating authority to a single member or panel. And so that would mean like a single NLRB member or a panel of NLRB members. But there could also be a delegating first level review authority to a intermediate review board. So is that covered in this?
That's covered in B.
That's in B. Okay.
I think Jeremy's right, Jeff.
Okay, I take it. That's fine.
All right, Jeff, anything else on?
No.
Okay, so let's now do, how about 4? Anything on 4?
You've got a stray F up there, just as a typo.
No, it's removed.
Okay.
I got that earlier.
Paragraph 5.
I do have a thing on 5, and maybe it says when a PAS official serves as a first level reviewer, agency should determine the circumstances in which review by the PAS official may be warranted. That sounds almost tautological. Do we want to say is authorized to serve as a first level reviewer, or do you want to modify the second review? I mean, isn't it saying when he serves as a reviewer, an agency should determine when he serves as a reviewer?
It's not meant to be tautological. The idea is that it shouldn't be done on an ad hoc basis. There should be some purposeful consideration of the grounds in the future in which the official should exercise review authority.
Well, that's what I was getting at when I said when a PAS official is authorized to serve, that sets up the condition, and then an agency should determine when he should actually do it.
I think it's less about the authorization. I mean, it's something along the lines of when a PAS official serves as a first level reviewer, the agency should develop a policy regarding the circumstances in which review will be exercised, something like that, or maybe exercised.
Well, what if you put the word such after which and before review? And if that's more problematic, then I recede.
Roxanne?
Just a quick thing at the end of the line D, should that be an or instead of an and?
This is Jack's favorite question.
Yeah, this definitely should be an or, unless you want to change the phrasing. in the first part because it's or we don't want to have them have to have all four of those things. We only want them to have one of those things.
I think Jack is right. Is there, with respect to the first sentence of paragraph 5, is everybody happy with the revision that's on the screen now? Any objection to that? All right, I think that takes us to paragraph 6 now.
Let me just say about 5. I know we discussed this in the first meeting about whether or not, you know, we sort of predetermined whether or not there's a prejudicial error and all that. And we resolved that by number 7 by saying that the parties are supposed to explain, you know, why they're seeking review based on these criteria. But it still seems, until you get to number 7, it seems a little odd to talk about the fact that these errors have been made, you know. I mean, that's what the review is for, to determine whether the error has been made. So, I mean, we had some language that was something like where there's been an allegation or something, you know, that these things that were happening, but we took it out in place of number 7. I still think it's a little uncomfortable. And maybe we could say, we could tie 5 and 7 together more. But
Jack?
I had a different question, so maybe was what Jeff talking about resolved?
I mean, Jeff, what would you propose by way of a change here?
I mean, I think we went over this before, but I think on number 5, I had some language that said something like, there's an allegation that the lower level adjudicator committed a prejudicial error, or there's an indication, or there's the lower level adjudicator may have committed a prejudicial error, putting it in the kind of conditional rather than just it's already happened. But I think the fact that we added number 7 is to explain that when somebody makes a petition, they should explain, you know, why these are all triggered. But I still think it's just kind of awkward because 7 comes after 5 and we don't know till you get to 7. You know, it's just, is there a way to say something about 7 in 5?
Jeremy?
Yeah, I think we had some language that probably got inadvertently pulled out, but I think the idea was review may be warranted if there is a reasonable probability that, and it could be from a petition, it could be sort of in reviewing cases for motion purposes.
Right.
Yeah.
That helps.
And here we have in A that actually in all of these, the lower level thing. So sometimes it refers to the decision, which seems okay, but sometimes it refers to the adjudicator. So we may want to sync that up with that later change we made.
Just remind me, I don't know if it was Jen or Matt, what did we decide to do? Was that is that something that the Committee on Style is going to address?
We did make a note for Committee on Style, yeah.
Okay.
But we should just flag these instances here. Like in A and C.
Yeah, and it's not just in this, it's throughout the document. So
Right.
we made a note to make sure that throughout, not just, you know, like throughout every page, that we're very consistent about that.
There are more than 20 appearances of the word lower in this document, so it'll take some coding, but the Committee on Style can take care of that.
Right.
Okay. All right, so that's resolved. That takes us to, I believe, paragraph 6. Anything on paragraph 6? 7.
In 7, is that about line 204? Is that supposed to be paragraph 5 and 6? Because it's like, otherwise it's referring to itself.
Yes, 5 and 6.
Good one, Renee.
Yeah, thank you, Renee. That's helpful. Eight, 9.
I had my hand up, Matt.
Oh, I'm sorry,
sorry.
Jack.
It's okay. This was about something before. I have a question for Jeremy and maybe others that were involved in this. But are there any circumstances under which a PAS official is not the final decision maker in an agency? In other words, where there might be a review, some intermediate level, but someone is PAS? Someone like who's inferior to the secretary, for example, but who's also PAS?
Yes. Yeah, you see that quite often in like cabinet departments. So, I mean, you'd probably still call them an agency head, but DEA adjudication is assigned by statute to the Attorney General. It's delegated to the DEA administrator. Within the Department of Transportation, lots of things are assigned to the Secretary of Transportation, delegated, say, to the FAA administrator. So lots of examples of that.
So what I'm trying to figure out is whether PAS is the right is always going to be the one that can provide precedential or uniformity or that sort of thing. That's what I'm wondering. Are there circumstances in which the exact problems that are caused by lower level adjudicators are actually also caused by PAS adjudicators, so that the department head needs to make a decision to resolve a problem of inconsistency or lack of precedential value or something like that?
What does the Veterans Review Board do? They make final decisions, right? The Secretary of Veterans Affairs never gets involved.
Right. Although
I was asking the opposite question, Jeff. Are there circumstances in which a PAS officials make intermediate decisions for a department?
Intermediate. Oh,
Intermediate.
Not that I found, Jen. I don't know if that you found any. Well, usually what I've seen is something is assigned to a cabinet level secretary and its final decision-making authority is delegated to another PAS official.
There's that God Squad.
But but the more you do these case studies, the more you realize how many unusual systems are out there. So I wouldn't foreclose the option that there is one.
I think regardless, this paragraph works, this language works. Jeremy?
I think so.
Okay. Jack, you happy? Paragraph 8. 9. 10. Can we just get 11? Thank you, Matt. 11. 12. 13. Paragraph 14. Lou.
Hi, Matt. I'm aware of where we are in the process here, and I have not chimed in before, but I was just reading this from the recusal perspective, and I thought maybe line 3, maybe government-wide or agency-specific ethics standards, because laws and regulations I thought was a little narrow. I mean, many of these agencies are operating on guidelines and or customs. We do have a cross-reference to the recusal recommendation, so I don't know that we need it again here, but that last sentence is a big sentence if one wants to sort of open it all the way up, but I don't think it's inaccurate.
So would you take out and regulations?
Yes. I mean, there's lots of ways to do that, but laws is also sort of redundant with regulations, right? So depending. So I thought that would be more inclusive.
Well, I think everyone's going to defer to you on this one, Lou. So why don't we move on to paragraph 15?
I'm going to make a note of that just for my personal journal.
It's expertise-based deference. 15. 16, we have the lower level issue. I really hope nobody has any additional changes on paragraph 17, but let's be sure of that before we move on. All right, let's move on to 18, please. Uh, 18, obviously, we've discussed in connection with paragraph 17. So unless there's any objection, move directly to 17, which also was discussed. And here, Jeff, I think this would be the time for you to chime in.
19, yes. So I looked at the two recommendations that Jeremy suggested, and there's nothing in either of them about this issue that I could find. But I did find the one on settlement authority, which is recommendation. Where's the recommendation number on this? 2022-6. And there is a line that says that in determining whether settlement agreements should be posted, the agency should consider factors including the extent to which disclosure, even after redaction or anonymization, would adversely affect, and then here's the key language, sensitive or legally protected interests involving, comma, among other things, comma, national security, law enforcement, confidential business information, personal privacy, or minors. So, as long as we explain what we mean by sensitive, I don't have, that's fine. I just don't want people to say, this seems sensitive to me, so I'm going to take it out.
So the one
Jeremy,
one about public availability of adjudication materials does say, in determining which materials, which includes decisions, to disclose, agencies should ensure that they have implemented appropriate safeguards to protect relevant privacy interests implicated by the disclosure of adjudication materials. It's arguably narrower, but that at least is in there.
Yeah, I was looking for the word sensitive, I guess. Okay. That'd be another alternative.
Yeah, Jeremy, what about incorporating that particular language directly or using it?
Yeah, I mean, it's long, but nothing wrong as long as it's substantively accurate for this category of materials versus settlement agreements.
Jeff?
Yeah, I mean, as long as it puts sensitive in this context, I'm okay with it. And I think Renee would prefer that too. So Committee on Style has to make it fit, but I think you can use the language.
So Matt, you just want to put some notation to the effect that will incorporate the language from the recommendation? And then the Committee on Style, I presume we will also decide whether to actually reference or cite the recommendation as in several of these other numbered paragraphs. Jeff, does that satisfactorily resolve the issue?
I think so.
Okay. Let's turn then to paragraph 20, I believe. Any proposed changes to 20? Let's turn to 21. I mean, I think I don't think there are any changes to 21, but let me just make sure that, give everyone an opportunity to weigh in if there are any final changes. And I think Adam is satisfied, if I recall.
Yes.
So, right, Adam?
Yep, all good.
Okay, so let's move to 22. Anything on 22? And that is our, Matt, is that our last paragraph here, 22?
Can I make one more comment?
Please.
If we're finished with the text. Adam and Renee have some comments first.
Okay. Are these on 22, Adam and Renee, or no? Are there any concerns with 22, or are we okay with 22?
I had one on 22.
Okay, let's turn to Renee first, and then we'll go to Adam on 22.
Why don't
Renee.
you do Adam's comment on 22 and then, because mine is about a different thing, and I apologize because I didn't look at my notes when we were talking about this other thing earlier. And it's more a stylistic comment than anything else.
All right, Matt, thanks for making that changing the cross-reference. Adam on 22, please.
Yeah, no, it was the thing that Matt fixed. So
okay. All right, so that we've addressed that. Renee, let's turn to you then.
All right, so mine is, and I really apologize, but I forgot, I wasn't looking at my notes earlier. On line, well, I don't know, it's in the preamble. On the earlier draft, it was line 83, so it might be a little later or something now. In fifth, the paragraph being fifth, that second sentence, which says this can be, this is a stylistic thing. There should be something after this, like this multiplicity of responsibilities or duties or something like that, so that this isn't just kind of hanging out there undefined.
Does that phrase you've added capture it?
Yes.
Broad range of responsibility. Broad range of. Do you want to say such responsibilities or?
Oh yeah, that's good. Yeah.
Okay.
Yeah, something.
All right. I don't think there'll be any objection to that. Renee, did you have anything else on the recommendation?
No, that was it. Thanks.
All right. Are there any other proposed? Jeff, did you have something? You look like you're.
Yes, okay. I did. Yeah.
Go ahead.
So, I'm sure the staff talked about this for hours, but I stumble over the use of the parentheses S throughout this recommendation. If you look at the first heading on the recommendation, when officers, past officials, I recognize that it can be useful to have, the S added on to some of these words. And sometimes you have to make a decision as to whether or not the resulting verb is going to be singular or plural. But I don't think you have to do it every time. So I think you could, in this heading, just say when an officer and then a past official. And, because later on, it's kind of explained. Now, there are some places later on where you might have to use this little S thing, but I would urge that you go through the recommendation one more time and try to weed out as many of these extra parentheses S's as you can, because it's too awkward looking.
Okay, so can we ask the Committee on Style to do that? And we'll just defer to the judgment of the Committee on Style. Jack, was your comment related to Jeff's?
Good.
Okay, so Jeff, you're satisfied?
No.
The Committee on Style is?
Yes.
Okay. Jack, what do you have?
I guess I'm just going to register because we're about to vote on the thing. I don't even know if I vote because I don't think I do because I'm a.
No, I believe I think you're a committee member, and I think you're
okay.
I think you do have the right to vote.
We're going to vote, and I'm going to vote in favor. But I want to just register again for the group my reservation, and that I have an overarching reservation about the whole project, and which is the project really about PAS officials or is it about agency head adjudication? Because it would seem to me that most of what we're talking about is about the idea of adjudication by agency heads. And one of the things we would allow, I think, is traditional, is that some agency heads delegate their adjudicative authority to other PAS officials. But I don't think PAS confers even principal officer status on anyone. And so I'm just overall concerned about whether this whole project is really about agency head adjudication rather than PAS adjudication. And I think that I would favor making it about agency head adjudication. I wouldn't be surprised if the council discusses something like this when it comes to them. But I'm going to vote yes, and I'm going to register this thought as a separate view on the record. But that's the way that's been an overarching concern of mine since I got involved with this project.
Before we leave this, I think I want to comment on Jack's qualm here, because I sort of had a qualm with the title of the whole recommendation, but now that he puts it that way, it seems even a little more inapropos, because the recommendation title seems to call into question or raise the issue of whether it's appropriate for Senate confirmed officials to participate in administrative adjudication. Well, of course it is, but we're not commenting on whether or not they should participate. We're trying to provide kind of best practices for their participation, and just focusing on PAS people may obscure the fact that we're really, as Jack said, most of these recommendations are concerned with the role of the agency head in administrative adjudication. So I sort of second his concern, and I think we should focus on the title a little bit.
It certainly seems like the words best practices for would be a good addition to the beginning of the title.
I guess one concern I would have, just speaking as a committee member, is, I mean, Mel, I guess the phrase best practices is included in the title of some recommendations, but presumably it could be included in the title of most recommendations. And so why this one?
I mean, I guess just to clarify that the recommendation isn't about the yes or no question, should Senate confirmed officials participate in administrative adjudication. I think Jeff's concern is a little different from mine, but I think it would be met by some revision of the title, because I do agree that the way the title is written, it almost seems like the question is whether there should be participation of Senate confirmed officials in administrative adjudication.
And does anybody read it along the lines of Jack to take a position on that question? Or is it agnostic on that question?
Doesn't take a position on it, but it just raises the issue in a way. And I think it unnecessarily might give people the impression that we are somehow questioning the appropriateness of Senate confirmed officials to adjudicate.
What if you just said structuring participation?
Well, is it only Senate confirmed officials though? Would it be clearer if we said participation of agency heads?
I think that's pretty complicated, because you get into the questions of what is an agency and who is an agency head. I mean, part of the issue is in Arthrex, they characterize the Court of Appeals for Veterans Claims as a tribunal within the executive branch, but that's not typically considered an agency. So you get into sort of terminological distinctions. I mean, I'll just go back to the way I interpret Arthrex, at least, is it speaks in terms of Senate confirmed officials. That's at least how the decision is framed.
Oh, Roxanne?
I would say that I hear what Jeff is saying, because when I first saw this project and the title of the project, my first thought was, oh no, is there a problem with the participation of Senate confirmed officials in agency adjudication? And I now don't have that problem, so I'm having a hard time wrapping my head around how to say that, because how to title it, because I'm not sure if I've lost that take on it purely because I've sat through these two meetings. Would it make any difference, Jeff, if the title was Senate confirmed officials apostrophe participation in administrative adjudication? Is that still raise the same concern? I just moved participation to after Senate confirmed officials.
That would be better. Are we really doing?
And then there'd be like an apostrophe after the S of officials.
Nina and then Renee.
Just very quickly, it seems like we're really talking about distributing authority between Senate confirmed and non-Senate confirmed officials. That said, I don't have a specific proposal for the title, but it's this seems like the recommendation is much more about when it's appropriate for Senate confirmed officials, when they receive the authority by statute to adjudicate, when it's appropriate to delegate that authority to non-Senate confirmed officials.
Renee?
Well, I was going to propose maybe having the title be something like roles of Senate confirmed officials in administrative adjudication. Because we really are describing.
Yeah, that's better than it was before, because it's not really raising an issue. It's just saying, we know they have roles and we're commenting on them.
I prefer the one with structuring to roles, because roles sounds like it's totally descriptive.
Structuring. Is that really the word? Is that what we're doing?
Because the laws and so forth actually structure the participation.
Do we see a consensus on a title change here?
I think we have a consensus we need to change the title.
I'm inclined to go back towards something with best practices.
Jeremy, I know you don't have a vote, but may I just ask what you think of that inclusion of best practices in place of structuring?
We've done it in some recent adjudication recommendations. There's precedent.
I mean, I think it does address the concern that's being raised here, I think.
One other thought, I don't have a super strong view, but is to say Senate confirmed officials and administrative adjudication. But best practices is okay too for me.
I think I like that better than best practices.
You like that better, Jeff?
Yeah.
Jeremy, do you have any thoughts on the? I actually kind of prefer Renee's formulation. I think, but I'm not. I don't feel strongly about it. Do you have a thought on this?
I have no concern.
One of my colleagues at AU wrote a large article called "Best Practices on Best Practices." He was
I know. Yeah.
He was kind of making fun of how so many people use best practices.
I mean, there are certainly plenty of ACUS recommendations that use this form of title. So I think it would be fine in that respect.
Yeah.
Jack, are you okay with do you approve of the title that Renee proposed?
Which one was Renee's?
Senate confirmed officials and administrative adjudication, the second one.
Yeah, that one I like less than the first one because it looks like it's purely descriptive.
Which is true of a lot of ACUS recommendations, though, isn't it?
Yeah, but this one isn't.
ACUS has one called choice of forum for judicial review.
But Jack, by definition, we're issuing a recommendation. So it's not purely descriptive. It's the title of a recommendation.
Okay. I'm fine. Persuaded.
Is anybody unpersuaded by Renee's suggested title? All right, so we have a new proposed title, and I say proposed because the Assembly, Jeremy, the Assembly will need to vote on the title change, right? or does
Correct.
the council need to, the assembly needs to vote on the title change?
Correct.
Okay. Along with the rest of the recommendation.
And of course, the report title doesn't need to change unless they want to change.
That's right. They probably don't, Jeff.
Probably not.
Anything else on the recommendation before we proceed to a final vote? Nothing, Jack. I can't get anything out of you at 4:50 here. All right. So Renee, Jeff, anyone, Adam, anyone else? So why don't we proceed to a final vote? Matt, what's the best mechanism for voting here? Should we do it? Should we do a voice vote, or should we do a hand raise vote? What's the or what a hand raise vote, would that work?
We did a hand raise vote this morning, but you could probably also ask for unanimous consent.
Can someone remind me about whether I can vote? I think maybe I cannot, but
I think you remember the committee.
Yes, I am a member of the committee. Okay, so I can vote. All right. Thanks.
Why don't we do it this way? All those in favor of the adoption of the recommendation say yay.
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 And opposed, nay. All right, so we have a recommendation to send, as Andy pointed out at the outset, to the membership with a stop at the council. Anything more? Andy, do you have any parting words for us?
Yeah, absolutely. Thanks, Matt. Thank you to everyone on the committee for the work throughout on this report and recommendation. Today was very constructive and very, very thoughtful. Thank you to Jen and Jeremy and Matt Bluth, and a special thank you to Matt Weiner for stepping up at the last minute here and running a very successful committee meeting.
Thank you, everyone. We'll see you at the plenary session.
Bye-bye.